One of the questions that I get asked the most frequently is, I was just charged with Penal Code Section 273.5 and it's my first offense. What's going to happen? And that is what we're going to be talking about in this video. And when I talk about Penal Code Section 273.5, I am talking about California Penal Code Section 273.5, which is corporal injury to a spouse or cohabitant. Basically, it's domestic violence. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be answering this frequently asked question that I get. I was just arrested. I bonded out for Penal Code Section 273.5. What's gonna happen? What am I looking at? Okay, so first of all, most of the time, if you were arrested for Penal Code 273.5, it is as a felony. So you can find that out on the sheriff's website. It will say like charge level F or M if it's a misdemeanor. But also if your bail was $50,000, that is felony bail typically. If it was lower, that doesn't mean that it's not a felony. You should look yourself up on the sheriff's website for Los Angeles County. Just look up Los Angeles Sheriff's website, inmate locator, type in your name, and then you'll be able to see that information right there. Also, if you got a citation or paperwork or something from your bail bondsman, it will say right there. Okay, so most of the time though, if the cops arrest you for that, they are arresting you for a felony. Now, if you bond out and you have a future court date, let's say in a few weeks or a few months, what is happening right now is that the prosecution, so okay, you get arrested, right? And the cop writes up a police report. And at that point, you know, you think, okay, I have this criminal case against me. I have to go to court on this certain day. That's what they make it seem like, right? Your bail bondsman says, hey, make sure you get there on that day. Maybe call me after, right? But actually, what happens is that the police officer writes up his report and then he gives it to the DA's office, the prosecutor's office. And the prosecutor has to look at that police report and decide, do I want to file charges as a felony? Do I want to file misdemeanor charges? Do I want to file, well, there's also, do I want to file a worse felony, but that's rare for 273.5. Or do I want to just not file altogether? So if you bonded out and you have court in a few weeks, a few months, what's happening right now is probably nothing. And when it gets closer to your court date, I would say within like maybe 2 weeks of your court date, but sometimes it's sooner, maybe 30 days, the prosecutor will look at the police report or whatever's in their file for you, and they're going to decide, do I want to file this as felony, misdemeanor, or not at all, basically, right? So that is what's going on right now. Now, you do have a chance. You have this golden window between the time you bond out and your first court date to have an attorney talk to the prosecutor, whether by submitting a packet with all the good things about you, your side of the story, or talking to them in their office or on the phone, over email, and try to get them to either not file, or if they're going to file as a misdemeanor. Now, if this was your first offense, right? And I think it's funny when people say first offense, because hopefully only offense, right? It's not like we're collecting them. Anyway, if it's your first offense and it is a 273.5 charge, you actually have a reasonable chance at getting them to not file in most cases. What they're going to be looking at is, okay, so anything your attorney submits on your behalf, which can be the good things about you, like your job, letters of recommendation, family life, like whatever it is, all the good things that can be gathered. Like when you're saying, hey, I'm a good person, don't send me to prison. All the reasons why you're saying I'm a good person, we want to get that into their file, right? So they're going to be looking at that. Another big thing that they're going to be looking at is injuries. So this is really big, and if the injuries were really severe to the other party, assuming that they had them, that is going to be something where your attorney really needs to try as hard as possible to get them to at least file as a misdemeanor, because those are the cases that sometimes get filed as felonies. That's much more likely to get filed as a felony if there are bad injuries, especially if the person had to go to the hospital. If the alleged victim is on your side, I mean, another frequently asked question I get is, can they just drop the charges? No, they cannot. Once they call the cops, once they arrest you, the cops come out, it is out of that person's hands. But they can write a letter, write a declaration under penalty of perjury with their side of the story. and your attorney can submit that. Also, I've been around doing this stuff long enough to know that sometimes in these relationships, maybe things are good at first with the alleged victim, but by the time the case is over, or we're getting, a few months into the case, things switch. So if we can get them nailed down to their story and it's favorable for you early on, we want to do that. Get all of that over to the DA's office. Now, look, domestic violence is one of the most common arrests in Los Angeles County. They cannot possibly prosecute all of these arrests, and they don't. About half the time, they don't prosecute them at all. They will just dismiss it or give it to the city attorney's office that would only handle it as a misdemeanor, and that's a whole separate video. But I mean, they can't possibly prosecute all these. If you have been arrested for domestic violence, you know how this goes. I mean, the cops come out, and they're pretty much, from the time that they come out, they're going to make an arrest. There's nothing you can say, probably, at that point, either the victim, alleged victim, or you, to get them to not arrest you, right? So there are all these people that are arrested for basically nothing. They don't have strong cases. They cannot prosecute all of them. So this is the type of case that, yeah, you've got a decent chance to get it either reduced or dismissed. So that's really important. Now, if you are looking up Penal Code Section 273.5, you might start to get scared because you're going to see things about prison time. Now, if it is your first time and there are no really bad injuries, I mean, I'm talking about like broken bones, I'm talking about, really severe stuff, unlikely that you'll go to prison. Possibly jail. In jail, typically, like the worst offer we see in these cases involving jail is like 120 days, of which you would do 12. I mean, that sucks, but that's like, if there are, that's for example, if there are like bad bruises in like your handprint on the person's arm, that's an example of one. If you really, there's not anything good to say about you, hopefully that's not true about you, but if there's not a whole lot that we can show to demonstrate that you're a good person, or at least trying to head in that direction. Sometimes I assign my clients to like, hey, if you don't have a dream, if you're not going to school or work or whatever, go get one. You need to go get one, figure it out, get one. Because we need to try to bolster the case and the good things about you, right? To make sure you don't go to prison. But most people, almost, and I think every single client that I've had, although don't quote me on that, but I can't think of a single client I've ever had for a 273.5 that actually went to state prison. Okay, so that's really unlikely. Don't get scared. Sometimes you will call attorneys who, some of them are like, they use scare tactics as like a sales technique. Don't get scared. They are probably just telling you that because then when they give you an offer of 120 days in jail, it's the first offer, it'll look good to you because you're not spending years in state prison. Okay, also, most of the time, 273.5 charges, even if it stays a felony. So let's say that the injuries are kind of bad. As long as you don't go to state prison, it's a wobbler and it can be reduced to a misdemeanor and expunged. Now, it cannot be reduced to misdemeanor and expunged until you are finished with probation if you get a probation offer. But it can be reduced and expunged. So your life is not over. I mean, there are certain jobs like lawyer, doctor, certain jobs where you have licensing where that is going to screw you up. But for most people, it's not going to be necessarily the end of the world because you will be able to get it off of your record. You will be able to get it expunged. So basically, do not panic. Do not buy into scare tactics. If you have a good attorney, many times we are able to get them to not file the case at all. And then if they file, to file as a misdemeanor. So at least worst case scenario is filed as a misdemeanor. And now all of these things that I've been talking about, I mean, we're talking about, basically if you were to take a plea deal, what you would get. That doesn't mean you have to take a plea deal. I mean, sometimes we will set these cases for trial and the only evidence against you would be the alleged victim. If the alleged victim doesn't show up and they have no other evidence, the case will be dismissed. I mean, there are all sorts of other things that can happen in these cases that are positive, and of course you can fight the case. But the purpose of this video is basically that when people call me panicked and they have this question, I know that they're not always getting this straight, honest answer from every single attorney. So I want to put this information out there so people that, got into a loud argument with their girlfriend, the neighbor called the cops came out and arrested them, saw a random bruise she already had on her arm and arrested them for felony 273.5 with 50K bond, I want to make sure that those people don't spend the next few months before their first court date in an absolute state of panic and anxiety. I hope that this video helped. If you do have 273.5 charges in Los Angeles County, call me. I mean, that is what I do. Most of my cases are those types of cases. I do have much more serious cases as well, but 273.5 is one of the most common arrests that occurs in Los Angeles County. So naturally then, I don't do DUIs, at least not on the misdemeanor level. Sometimes if somebody's been injured or it's a strike offense or something, but I don't do those types of cases. So in terms of like the bulk of my cases, it is the 273.5, and I can definitely help you. So if you do have a case like that, feel free to book a consultation with me. You can find my number or the link to book down below.